of that opinion say aye. And as our contrary opinion say nay, the ayes have it.
A bill for an act of parliament to establish the Kenya Industrial Research and Development Institute and for connected purposes.
We go to the next order.
Nine, the Proceeds of Crime and Anti-Money Laundering Amendment Bill, National Assembly Bill number 39 of 2021.
Honorable members, before I proceed to that particular order, I wish to issue a communication first to guide members in transacting that particular business that is coming immediately after this. Honorable members, you will recall that during the afternoon sitting on Thursday, December 2nd, 2021, before the order for second reading of the Proceeds of Crime and Anti-Money Laundering Amendment Bill, National Assembly Bill number 39 of 2021 was read out, the member for the Raka, the Honorable George Gitonga Murugara, rose on a point of order seeking the Speaker's guidance on the constitutionality of certain clauses of the bill. The Honorable Murugara claimed that the bill, as published, contains provisions that fail the test of constitutionality and therefore should not proceed with it. He singled out clauses 2 and 9 of the bill, whose import is to include advocates, notaries, and other independent legal professionals as reporting institutions obligated to report reasonably suspicious financial transactions likely to fall within the meaning of the money laundering to the Financial Reporting Center. He stated that the two clauses, if passed, would be unconstitutional on the following grounds. One, that singling out advocates and accountants, among other professionals, and designating them as reporting institutions violate Article 27(4) of the Constitution, which prohibits any form of discrimination, and two, that requiring the advocates under the law reporting financial dealings of their clients would erode the settled legal principle of advocates-client confidentiality. Honorable members, the fourth chairperson, who was presiding then, took cognizance of the weighty nature of the claims by the Honorable Murugara and did permit several other members to weigh in on the matter. The members who spoke included the Honorable Dr. Otiende Amolo, the Honorable Aden Duale, the Honorable Peter Kaluma, the Honorable Peter Mwadi, the Honorable Gladys Wanga, the Honorable Dr. Patrick Musimba, the Honorable Millie Odhiambo Mabona, and the Honorable Dr. Makali Mulu. In their submissions, the issues raised by the Honorable Murugara, the overreaching sentiment of most members converged on the question of constitutionality and propriety of the bill. Honorable members, for record, I wish to inform the House that before raising the matter at hand on the floor of the House, the Honorable Murugara had written to the Speaker on 2nd December 2021, requesting that he be given direction on certain issues regarding Proceeds of Crime and Anti-Money Laundering Amendment Bill 2021 before its second reading. In my estimation, the matters raised by the member were weighty and could not be adequately responded to by way of mere correspondences. It was the view of the Speaker that the floor of this House, of this chamber, has been and shall remain most appropriate place for the House to address matters of such importance to the populace as constitutionality of a bill. It will be recalled, following the issues raised by the honorable members, the Speaker directed that the debate on the second reading of the bill proceeds so as to accord members an opportunity to debate on the merits and demerits of the bill and raise any other constitutional matters therein. He, however, ordered that the question for the second reading shall not be put until a considered ruling on the issues raised by the members has been rendered, which I hereby proceed to do. The honorable members, having reviewed the letter by the Honorable Murugara and distilled the contribution made by other honorable members following the point of order raised in the House, I have isolated 3 questions that require my determination, and these are the following. 1, whether the Proceeds of Crime and Anti-Money Laundering Amendment Bill, National Assembly Bill number 39 of 2021, is properly before the House. 2, whether some proposals in the Proceeds of Crime and Anti-Money Laundering Amendment Bill, National Assembly Bill number 39 of 2021, seeks to limit fundamental rights and freedoms and therefore render the bill unconstitutional. And 3, whether the inclusion of advocates as reporting institutions for suspicious financial transactions in matters proposed in the bill erodes the legal principle of advocate-client confidentiality. Honorable members, before I guide the House on the pertinent questions for determination, it is worth noting that Articles 3 and 10 of the Constitution oblige the Chair to respect and uphold and defend the Constitution. As you are aware, all businesses that come before the House is approved by the Speaker. Among other considerations, the Speaker applies his mind as to the constitutionality and otherwise of such business as contemplated under Standing Order 47.3. Let me also hasten to add that notwithstanding the approval of any business by the Chair under standing orders, it has now become an established parliamentary practice of this House that a question of constitutionality or otherwise of any matter under consideration by the House may be raised at any stage of its consideration. Indeed, my predecessors and I have been invited on several occasions to guide the House on issues constitutionality of various matters before the House. Permit me, honorable members, to highlight a few such cases for benefit of the House and general public. Members who have served in the 11th Parliament will recall that the Speaker was invited to rule on constitutionality of several bills. First, on 23rd July 2013, the member for Suba South, the Honorable John Badi, who is currently the leader of Minority Party, sought the Speaker's guidance on whether it was constitutional for the House to consider the National Police Service Amendment Bill 2013 and the National Police Service Commission Amendment Bill 2013. In this case, it had been argued that the 2 bills contradict the provisions of the Constitution. I am on record as having determined then that the member failed to demonstrate the nexus or close connection between the specific clauses of the bill and the specific provisions of the Constitution that those clauses offended. Additionally, I guided that where any nexus was drawn, the proposed amendments were indeed enhancing the functions and powers of the National Police Service Commission and not contradicting any provisions of the Constitution as claimed in the point of order that was raised then. As such, not having found any provisions that offended the Constitution, I directed that a bill proceed to the second reading. Second, honorable members, on the 11th December 2014, during the consideration of the Security Laws Amendment Bill 2014, several members rose on a point of order and sought the Speaker's guidance on the general admissibility and constitutionality of the bill. The 2 key issues that stood then in the argument advanced by the members who spoke. The first issue was that adequacy of public participation in light of Article 118 of the Constitution and absence of a report of the relevant committee on the bill. The second issue related to limitations of rights and fundamental freedoms contrary to Article 24 of the Constitution. In my communication then to the House, I guided as follows. That 1, with respect to public participation, the clerk had indeed published the notice in the daily newspapers inviting interested members of the public to give views on the bill, and that the precedent of the House has been that the absence of a report of a committee on a bill does not prevent a bill from proceeding to second reading. And 2, with regards to the limitation of rights and fundamental freedoms, I noted that Article 24(1) of the Constitution permits limitation of certain rights by law, which can only be done by Parliament as the sole law-making authority. Hence, it was my finding that it was only fair that I accord the House the opportunity to satisfy itself that the criteria which set out in Article 24 was complied with, or make an appropriate determination by way of a decision at various stages of its consideration of the bill. I therefore allowed the House to proceed with the bill and make decisions on whether or not to accept the bill as proposed, or make necessary amendments to reflect the wishes and meet the obligations that Article 24 of the, under Article 24 of the Constitution. Honorable members who are standing there, can you please walk in, because it might still take a few more minutes. The honorable member from Muranga, please be a little faster. Order. So I proceed, honorable members. Honorable members, the third case of interest to the instant matter is that of the Military Veterans Bill 2013. Other than the concern of being a money bill, it was argued that by proposing to establish a government department headed by a Director General, an advisory council, and a Military Veterans Appeal Board, the bill offended the Article 132(4)(b) of the Constitution by usurping the powers of the President to establish offices in the public service. In my guidance to the House, I directed the Departmental Committee on Defense and Foreign Relations to further engage the Attorney General and the Cabinet Secretary for Defense to shed light on the issues of constitutionality of the bill and table a report for the Speaker to guide the House on how to proceed. The bill lapsed, and so the intended guidance never materialized. Honorable members, from the foregoing examples, you will notice that the Speaker has been hesitant to outrightly declare a bill as unconstitutional. The Speaker has consistently refrained from curtailing the House from considering a bill where adequate opportunity for the House to cure any alleged unconstitutionality exists. I have stated before, and do reiterate, that the role of the Speaker is facilitative, not obstructive. Where it is within the power of the House to take actions on a matter, which action is likely to remedy the question of doubt cast on the constitutionality of a matter before this House, I must trust that the House shall act in the best interest of the people, which it represents, unless compelling reasons exist to the contrary. Having shared the brief history, honorable members, let me now turn to the first issue for determination, which is whether proceeds of crime and anti-money laundering amendment bill, National Assembly number 39 of 2021 is properly before the House. The Honorable Duale is on record as having wondered why the alleged unconstitutional amendments contained in the bill have been reintroduced in the House at various times between 2015 and 2021. He claimed that any bill that fails the constitutionality test cannot be cured even if one keeps reintroducing the bill and bringing the same amendment and sneaking them through various bills, whether it is through amendment of the statute law or through financial bill. By alleging that the proposed amendments were being sneaked to the House through various bills, the ranking member was, in principle, casting aspersion on the propriety of the bill before the House. Honorable members, I have reviewed the record of the House, and indeed I do agree with Honorable Duale, but only on one fact, that this is not the first time that the impugned amendment proposed in the Proceeds of Crime and Anti-Money Laundering Amendment Bill 2021 have been introduced in the House. The first attempt to the amendment to the Proceeds of Crime and Anti-Money Laundering Act, which is popularly known as POCAMLA, was in 2015, when the then leader of Majority Party, the Honorable Duale, introduced the Proceeds of Crime and Anti-Money Laundering Bill 2015. The principal object of the bill then was to amend the Proceeds of Crime and Anti-Money Laundering Act, Cap 598, to enhance the powers of the Financial Reporting Center, to impose civil penalties, and to take administrative action against non-compliance with directives of the center. It is important to note that the bill listed accountants as among the designated non-financial businesses or professionals with obligations to report suspicious financial transactions to the Financial Reporting Center. This bill was passed and assented to in 2017. In 2016, the Honorable Duale, then the leader of Majority Party, introduced in the Statute Law Miscellaneous Amendment Bill 2016, which sought to inter alia amend the Proceeds of Crime and Anti-Money Laundering Act to remove the position of Deputy Director of Financial Reporting Center for the smooth running of the center. The then leader of Majority Party formally withdrew the said proposed amendments, and I did communicate their withdrawal to the House on February 9, 2017. Honorable members, it was in 2018 that the House seized of the amendments of simpler imports to those contained in the bill presently before the House. Through the Statute Miscellaneous Amendment Bill 2018, National Assembly Bill number 12 of 2018. Among the statutes that bill proposed to amend was POCAMLA 2009, and of interest was a proposal to amend Section 2 of the Act as follows. By deleting paragraph E on the definition and expression designated non-financial business or professionals, and substituting therefore with the following new paragraph. Accountants who are sole practitioners, partners, or employees within professional firms. And two, by inserting the following new paragraph immediately after paragraph F, which was FA. Advocates, notaries, and other legal professionals who are sole practitioners, partners, or employees within the professional firms. And FB, trust and company services providers. Honorable members, you may recall that on 28 August 2018, the member for Arieda, the Honorable Dr. Otienda Amolo, raised a point of order challenging constitutionality of the Statute Law Miscellaneous Amendment Bill, National Assembly Bill number 12 of 2018, in its entirety. Among the arguments by the Honorable Dr. Amolo and other members who spoke cited the above mentioned amendment as being in violation of the Constitution and deserving to have been contained in a miscellaneous amendment, and not deserving to have been contained in a miscellaneous amendment bill. In respect of this matter, I did permit the House to proceed with the second reading and subsequent stages of the bill and take conscious decision on the contested proposal in one way or the other. The Hansard report of the House on 15th November 2018, when the House considered the Statute Miscellaneous Amendment Bill 2018, National Assembly Bill number 12 of 2018, in the Committee of the Whole House, records the then chairperson of the Departmental Committee on Justice and Legal Affairs, the Honorable Chep Tumo, moving the House to delete the clauses of the bill that were proposing to include the advocates and accountants as reporting institutions. In this justification, the chairperson is on record as stating as follows. We are, and I quote, we are proposing the deletion of Section 2 because this is a very serious step. It requires wide consultation, and we cannot deal with this under miscellaneous amendment. That is the basis and justification of that. That is the same case with Section 48, which we will do later. I close the quotes. The House indeed, members who are, can you please take your seats, those members standing? Yes, take your seat, Honorable Member. You don't need to press anything for now. Just take your seat, please. So then I proceed, Honorable Members. The House did agree with the committee, and the two provisions were forthwith deleted from the bill. It is, however, instructive to note that there was no mention of the unconstitutionality of the said provisions as the ground for recommending their deletion. Instead, the committee cited the need for which such amendments to be contained in a separate bill in order to allow wider public participation. Honorable members, the same amendment was reintroduced in the Finance Bill 2019 under clauses 50 and 51 relating to the Proceeds of Crime and Anti-Money Laundering Act. Their introduction elicited concern with the House and external stakeholders alike. At the time, two overreaching arguments arose. First, it was claimed that the financial bill principally addresses the issue of taxation and revenue-raising measures and should therefore not be used to introduce proposals such as those amending the Proceeds of Crime and Anti-Money Laundering Act, which are not incidental to taxation or revenue-raising measures. Secondly, it was claimed that the amendment to the Proceeds of Crime and Anti-Money Laundering proposed to limit the fundamental rights and freedoms without satisfying the criteria set out in Article 24 of the Constitution on the matters of limiting fundamental rights and freedoms in the statute. In my guidance to the House on 19th September 2019, I observed that the Article 24 of the Constitution permits limitation of certain rights and freedoms by law. Hence, arguments that clauses 50 and 51 of the Finance Bill 2019 ought to be excluded from consideration of the House on account of limiting constitutional rights seem not to hold any water. With regards to compliance of the criteria set out in Article 24 of the Constitution, I observed that the extent that the Financial Bill 2019 had proposed to amend sections of the Act with discernible link to the limitation of rights guaranteed in the Constitution, the said amendments ought to comply with the requirements of Article 24(2) of the Constitution. Consequently, honorable members, I determined that clauses 50 and 51 of the Finance Bill 2019 had not been accompanied by an additional provision stating the intention to limit the rights to privacy and nature and extent of limitation in relation to the new categories of the professionals sought to designate the reporting institution under Proceeds of Crime and Anti-Money Laundering Act 2009. I therefore found that the two proposed provisions failed to comply with the standards of disclosure set out in the Constitution and therefore were procedurally defective. And I consequently ordered the exclusion of those two provisions from the consideration of the House during the second reading and subsequent stages of the bill. In so guiding, I was very clear that my determination related to the procedural defects in the manner in which the proposed amendments had been presented and not their constitutionality or otherwise. Honorable members, it is instructive that the Departmental Committee on Finance and National Planning, after undertaking public participation on the Finance Bill 2019, had also recommended that the amendments relating to POCAMLA be excluded from the Finance Bill. The committee noted that the said amendments had such ramifications and ought to have been proposed on a separate bill instead of the omnibus bill. The committee made reference to the submission of the Law Society. The committee made reference to the submission by the Law Society of Kenya and the amendments that the amendments impacted several principles, practices, and laws touching on subject of legal profession, privilege, advocate-client confidentiality, cemented under evidentiary rule of privilege under law of evidence and common law principles adopted under the Judicature Act. In these regards, the committee is on record as having taken cognizance of the weighty submissions by the Law Society of Kenya and recommended as follows at paragraph 192 of the report on consideration of the Financial Bill 2019. I quote, "The committee resolved to reject the proposed amendments in the bill to allow introduction of the amendments to the POCAMLA and not through miscellaneous amendments. This will allow extensive public participation," close quotes. Honorable members, a plain reading of the committee's observation and recommendations indicate that there was nothing unconstitutional about the proposed amendments. What arose was the need to have the proposed amendments published in a separate substantive bill in order to allow the sufficient public participation and public participation. And now, therefore, out of this long and winding journey, a separate substantive bill to amend the Proceeds of Crime and Anti-Money Laundering Act 2009 has been introduced and is now before the House. Honorable members, the foregoing recap of the meanderous journey and attempts to amend the Proceeds of Crime and Anti-Money Laundering Act since 2015 contradicts the view that a mischievous attempt had been made to sneak undesirous and unconstitutional amendment to this House, as claimed by the Honorable Aden Duale. It is inaccurate for certain members to have claimed that the amendments in the question has been severally rejected on account of unconstitutionality. Clearly, the only reason on record having consideration of the said amendment by the House whenever they were introduced were the structural and procedural errors which regards to the form of the amendment and the vehicle through which they were proposed to be introduced in the House. With regards to the Proceeds of Crime and Anti-Money Laundering Amendment Bill, National Assembly Bill number 39 of 2021, as currently before the House, I note that in introducing the bill in the House, the leader of Majority Party has satisfied the procedure prescribed under Standing Order 114, which is introduction of bills. In addition, the procedural defects that sounded a death knell on the previous attempts that I have narrated seem to be fully addressed. Maybe those members can also take their seat. I have a few more minutes to take. Members now can resume their seats. Those who are leaving can do so quickly. So, honorable members, Standing Order 47.3 places a specific obligation on the Speaker to exclude. Sorry, honorable members. Let's start from. So, of particular interest is that unlike previously when the proposed amendments were contained in an omnibus bus, they are now published in a separate substantive bill. I therefore find that the Proceeds and Anti-Money Laundering Amendment Bill, National Assembly Bill number 39 of 2021, is properly before the House, and nothing precludes the House from considering the bill in the remaining stages. This settles the first issue regarding the propriety of the bill before the House. Honorable members, let's now proceed to the second matter, which is whether the proposal in the Proceeds of Crime and Anti-Money Laundering Bill, National Assembly Bill number 39 of 2021, that seeks to limit fundamental rights and freedoms and render the bill unconstitutional. Members opposed to the highlighted amendments are that the proposals contained in the bill single out advocates specifically and impose obligations on them. This in turn, the members further unfairly discriminates against advocates as professionals and renders the proposed amendments unconstitutional. Before I delve into this question of constitutionality, it's worth noting that the member for Homa Bay Town, the Honorable Peter Kaluma, alludes that the debate arising from the point of order no member demonstrated with precision the nexus between any alleged violation of any one of the Article 264 of the Constitution and Clause 16 contained in the bill. I'll therefore attempt to address the issues as discerned to be violation of the constitutional-based arguments of members. Honorable members, Standing Order 47.3 places a specific obligation on the Speaker to exclude any motion from being debated or direct the amendment of a motion in an appropriate format where the motion is either offends the Constitution, an act of Parliament, or standing order. The standing order provides, and I quote, that if the Speaker is of the opinion that the proposed motion, A, is one that infringes on the debate, or the debate on which is likely to infringe any of these standing orders, and B, is contrary to the Constitution or an act of Parliament without expressly proposing an appropriate amendment to the Constitution or that act of Parliament. The Speaker may direct either that the motion is inadmissible or that notice of it cannot be given without such alteration as the Speaker may approve, or the motion be referred to the relevant committee of the Assembly pursuant to Article 1142 of the Constitution. Over years, honorable members, I have not shied away from invoking the provisions as indeed will be recalled during the debate of this very matter in the past. However, the expected invocation calls for clear and discernible contraventions of the law to avoid misuse. For clarity, the impugned clauses 2 and 9 of the bill proposes the advocate to make advocates and notaries and other independent legal professionals who are sole practitioner partners or employees within professional firms as designated as non-financial business or professional required to report suspected money laundering and related activities to the Financial Reporting Center. The concern of Honorable Murugara and other members challenging the constitutionality of the bill is that the amendment runs short of age-old legal practice of advocate-client confidentiality, the right to privacy, and the right of access of information as guaranteed in the Constitution. However, as members are aware, the Constitution is very clear on the rights and freedoms that may not be limited under any circumstances. For certainty, Article 25 of the Constitution provides as follows, and I quote, "Despite any provisions of this Constitution, the following rights and fundamental freedoms shall not be limited. A, the freedom from torture and cruel and inhuman or degrading treatment or punishment. B, freedom from slavery or servitude. C, the right to a fair trial. And D, the right to an order of habeas corpus." A close reading of Article 25 of the Constitution therefore reveals that the Constitution allows this House to limit any other right or fundamental freedom subject only to protection outlined by the Constitution. Up to that point, and without interrogating the merits of the proposal, the arguments that Clause 2 and 9 of the bill, insofar as they allegedly limit the rights to privacy and therefore ought to be excluded from the consideration of the House, seems implausible, in my view, and in outlining the limitation of rights and fundamental freedoms of the Constitution provided for in Article 24, 1 and 2, and I quote, "A right or fundamental freedom in the Bill of Rights shall be limited except by law, and then only to the extent that limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom, taking into account all relevant factors, including the following: A, the nature and right of fundamental freedom; B, the importance of the purpose of limitation; C, the nature and extent of limitation; D, the need to ensure that the enjoyment of rights and fundamental freedoms by any individual does not prejudice the rights and fundamental freedoms of others; and E, the relations between the limitation and its purpose, and whether there are less restrictive means to achieve the purpose. And two, despite clause 1, are provisions in legislation limiting the rights and fundamental freedom in the following cases. A, in case a provision enacted or amended on or after the effective date is not valid unless legislation specifically expresses the intention to limit that right or fundamental freedom and nature and extent of the limitation. And B, shall not be construed as limiting the rights and fundamental freedoms unless provisions is clear and specific about the rights and or freedom to be limited and the nature and extent of the limitation. And C, shall not limit the rights or fundamental freedoms so far shall not limit the rights and or fundamental freedom so far as to derogate from its core essential or essential content. So, honorable members, as observed by the Speaker's communication of 19th September 2019, when the same matter arose during the consideration of the Finance Bill 2019, Article 24(2) of the Constitution requires any provisions enacted or amended on or after 24th August 2010 to expressly stipulate the intentions to limit a fundamental right or freedom and the nature and extent of the limitation of the provisions to be valid. Further, it has been the practice that these stipulation be contained in the substantive section of the bill and not just in a statement or memorandum of object and reason. As I guided then, in regards to Financial Bill 2019, there was a requirement that an additional provision stating the intention to limit the right to privacy and nature and extent of the limitation in relation to the new categories of professionals it seeks to designate as reporting institution under Proceeds of Crime and Money Laundering Act 2009. The question that follows, therefore, is whether in seeking to limit the rights of privacy, the bill expressly provides for this, keeping with the constitutional dictates. Honorable members, these are members who've just left. Now come in, take your seats. Honorable Kwame, take your seat. Order, Honorable Nominee 001. That is being very uncourteous. So, honorable members, the long and short of it, the honorable member is that unlike the previous cases regarding Financial Bill 2019, Clause 15 of the Proceeds of Crime and Anti-Money Laundering Amendment Bill 2021 expressly provide for the nature and extent of limitation of rights. This, in my view, constitutes sufficient disclosure in as far as the constitutional requirement of Article 24 is concerned. Honorable members, it is instructive to note that this is not the first time that this House is being confronted with the need to consider limitation of rights as provided for in the Constitution. When faced with similar matter during the consideration of the Narcotic and Psychotropic Substances Control Amendment Bill 2020, the Departmental Committee on Administration National Security approved the express limitation of rights to privacy by, among other things, allowing the interception and retention of certain communications to aid gathering of evidence related to commissions of an offense under the Principal Act. The inclusion of the express provisions of the nature and extent of limitation of the rights affected by the bill aligned to the bill was with the Constitution. The question as to whether the justification provided for the limitation of proposed is adequate is one that only this House, in exercise of its exclusive legislative mandate, can consider and either agree with, enhance where a gap is noted, or disagree with it entirely. Interestingly, The honorable members, just recently on 15th November 2021, just a month ago, the High Court of Kenya, in petition number 134 of 2019, held as follows with respect to limitation of certain rights and freedoms. That on the right of privacy, as O. Higgins, CJ, commented in Norris versus Attorney General 1984, IR 587, a right to privacy can never be absolute. It has to be balanced against the state duty to protect and vindicate life. What needs to be done, as was recognized in Campbell versus MGN Limited 2004 to AC 457, is to subject the limitation and the purpose it intended to serve to a balancing test, whose aim is to determine whether the intrusion into individual privacy is proportionate to the public interest to be served by the intrusion. So, honorable members, in considering the proposal in the bill as against the claim of intrusion of privacy and other rights, the House is expected to weigh the claim as against the public interest that the state seeks to secure through proposed legislation. At the face value, the limitation is contemplated in Clause 2 and 9 of the bill, which seemingly seeks to avail the state the legal framework for enforcing integrity, transparency, and accountability, being inviolable national values and principles of governance accordance with the Article 410 of the Constitution. Therefore, honorable members, to the extent that the Article 24 of the Constitution permits limitation of the certain rights and fundamental freedoms by law, and the fact that the Proceeds of Crime and Anti-Money Laundering Amendment Bill, National Assembly number 39 of 2021, explicitly discloses the intended limitation as required in the article, there exists no procedural defect in the bill to preclude the House from considering it at this stage. Honorable members, with regards to the reasonability and justifiability of the nature and extent of the limitation of rights as contained in the bill, as your Speaker, I wish to state that the determination falls outside the remit of the Speaker. I will therefore not delve into the merits or otherwise of the matter, safe to say that due process has thus been followed in processing of the bill. In any case, there exist various levels for determination of such matters, including Parliament, through the various legislative processes, by the judiciary, through interpretation and or review of any legislation passed by Parliament, and by various enforcement bodies as provided in law. Indeed, Article 165(3) of the Constitution provides for direct determination of such questions of infringement or violation of the bill of right by High Court whenever they arise. So, honorable members, the matter of alleged discrimination of advocates and accountants by the bill also arises from the question raised in the constitutionality of the bill. Article 27 of the Constitution provides for equality and freedom from discrimination for all persons. Clause 4 provides as follows, and I quote, "The state shall not discriminate directly or indirectly against any person on the ground of race, sex, pregnancy, marital status, health status, ethnic or social origin, color, age, disability, religion, conscience, belief, culture, dresses, language, or birth." Close the quote. The inclusion of advocates as profession required to report to suspicious financial transaction law has been cited as discriminatory and prejudicial against the legal practitioners. However, my reading of the Principal Act, which the bill seeks to amend, indicates that there are other professionals already designated as reporting institutions. Indeed, Section 48 of the Principal Act provides for, among other persons, accountant when preparing or carrying out transactions for their clients in specified transactions, trusts or companies, service providers acting as formation agents of legal persons, a director or secretary of a company, a partner of a partnership, or similar position in relations to other legal persons, providing registered office, business address or accommodation, correspondence or administrative address for a company, acting as or arranging for another person to act as a nominee shareholder for any person. You will agree with me, honorable members, that this incorporates other professionals in other various capacities where undertaking such specified actions. I am aware of the proceedings that have been instituted to the effect that inclusion of those professionals are discriminatory. In any case, I have explained earlier, and the courts have also held that the Constitution permits certain level of discrimination in law as long as such discrimination is appropriate to the public interest to be served by such discrimination. In fact, my analysis of contribution of the member for Suba, that's the Honorable Millie Mabona Odhiambo, from the proceedings that subject order, honorable members. I will repeat that, in fact, in my analysis of the contribution by the member for Suba North, the Honorable Millie Odhiambo, from proceedings of the subject, I could sense that she noticed the high public interest that proposed amendments seek to address. For the sake of concerned members, the Honorable Millie indicated that her intention to propose amendment that would try to rectify the alleged discriminatory provisions, if indeed any exists. And I have indicated prior to the determination of whether there will be any discrimination that will arise from the bill can only be conclusively addressed by a court of law. The role of this House is to legislate. We cannot put the cart before the horse, and debate concerns reserved for another arm of government after the House dispenses with its role. It is therefore only fair that we allow the bill to proceed to the next level and let the competent authorities determine any subsequent matters that shall and may arise at the stage of the lawmaking. It would be premature to conceive that the bill is discriminatory. This settles the second questions on the constitutionality and propriety of the bill. Honorable members, the final concern that was raised was whether the proposed amendment to clauses 2 and 9 of the bill erodes the legal principle of advocate-client confidentiality. On this question, I wish to single out the following as explained by some members who spoke on this matter. The members who are standing, please take your seats for the last lap. We only have another probably 5 minutes to dispense with this, so honorable members who may need to stretch, you can hold your horses briefly. Okay, honorable members, let's proceed and finalize it. So I will start again, honorable members. The final concern raised by was order. Honorable Atandi, take your seat. Take your seat quickly. Yeah. And also the member for Nyandarua. Forget about logging in. You don't need to. We are not using that gadget too much now. Okay. So the final concern honorable members raised was whether the proposed amendments in clause 2 and 9 of the bill erodes the legal principle of advocate-client confidentiality. And on this question, I wish to single out the following as explained by some members who spoke on this matter. That the said principle of advocate-client confidentiality is not founded in the Constitution of Kenya or any other statute. Thereof, rather, it is based on the legal practice, And two, that even if it were, it would ordinarily play second fiddle to the Article 10(2)(c) of the Constitution, which elevates principles of values and good governance, integrity, transparency, and accountability to an inviolable status. It is therefore inconceivable that legislating in the manner proposed in the bill would cause the principle to be violated unduly. I do note that the Proceeds of Crime and Money Laundering Act 2009 is an act of parliament passed by this House. In passing the act, this House took cognizance of the advocate-client relationship and included it in Section 18 of the Act. For avoidance of doubt, it provides as follows, and I quote, headed the client-advocate relationship. 1, notwithstanding the provisions of Section 17, which is secrecy obligation overridden, nothing in this act shall affect or be deemed to affect the relationship between the advocate and his client with regards to communication of privileged information between advocate and client. 2, provisions of Section 1 shall only apply in connection with giving of advice to the client in the course and for purpose of professional employment of the advocate in connection and for the purpose for any legal proceedings on behalf of client. 3, notwithstanding any other law, a judge of the High Court may, on application being made to him in relation to investigation under this Act, order the advocate to disclose information available to him in respect of any transaction or dealing relating to matter under investigation. And 4, nothing in this subsection 3 shall require the advocate to comply with an order under that subsection to the extent that such compliance would be in breach of subsection 2. So this, in my view, honorable members, renders the concern mute. In the event that the aggrieved members feel the statutory enhancements of the principle in the Act has been affected in any way by the amendment proposed in the bill, they remain at liberty to propose amendments to further buttress it for consideration of the House. Indeed, pursuant to the communication of the special sitting, this House, and inviting the submission of any proposed amendment to the bill, I can confirm that the Office of the Clerk is in receipt of amendments by the Leader of Majority Party and the Chairperson of the Committee on Finance and National Planning. These, I believe, shall inform the debate of the bill and allay fears of the concerned members. I wish to reiterate that the Constitution grants this House exclusive lawmaking powers. Towards this end, I propose that it has been brought to this House under the name of the Leader of Majority Party. The proposal accords with it several directives that the House has given with regards to the manner in which the proposals should be introduced and the form that it should be in. The only thing that remains is therefore that the question of whether the House agrees with the content of the bill, either fully or partly, after proposing the necessary amendments. Any member is well within the right to support, oppose, or propose amendments to the bill. Honorable members, as you are well aware, I, as your Speaker, only preside and I do not debate or vote on any question proposed for determination in the House. In summary, therefore, I wish to guide the House as follows. That 1, that the Proceeds of Crime and Anti-Money Laundering Amendment Bill, National Assembly number 39 of 2021 is properly before the House. And in introducing the bill in the House, the Leader of Majority Party has satisfied the procedure prescribed in the standing order and previous guidance issued by the Speaker. 2, that the proposal contained in the Proceeds of Crime and Anti-Money Laundering Amendment Bill, National Assembly Bill number 39 of 2021, seeking to limit certain fundamental rights and freedoms safeguarded under the Constitution, do not, in my view, render the bill unconstitutional. The bill explicitly discloses the intended limitation and purpose and extent of limitation as required by Article 24 of the Constitution. 3, that the inclusion of advocates as reporting institution for suspicious financial transaction in the manner proposed in the Proceeds of Crime and Anti-Money Laundering Amendment Bill, National Assembly Bill number 39 of 2021, does not at the face value erode the legal principle of advocate-client confidentiality. Section 18 of the Proceeds of Crime and Anti-Money Laundering Act 2009 currently provides for entrenchment of the principle. Any member seeking to buttress the principle further in light of the amendments proposed by the bill is at liberty to propose the appropriate amendment for consideration. In conclusion, honorable members, allow me to state that I have shared the above information for guidance of the House in considering the Proceeds of Crime and Anti-Money Laundering Amendment Bill, National Assembly Bill number 39 of 2021, and for your making decision in the manner you may so wish as required by the Constitution. I wish to emphasize that the matter raised by the member for Tharaka, and indeed contribution by other members, are very critical and contribute to the development of our parliamentary and legislative practice and procedure. Such instances enable us to self-reflect and to ensure that every step that we take as a House is carefully considered before a decision is made. This House is accordingly guided, and I wish therefore to proceed to put the question when time comes for you to make a decision one way or the other. I thank you. So, honorable members, take your seat for you to make the decision. Other members, take your seats. Other members. The member for Tharaka Nithi. Oh, no, that's the member for Naivasha for sure. Take your seat, please. Oh, order, members. Order. The rest of the members might freeze where they are. Freeze, honorable member. So then, honorable members, I proceed to put the question, which is the Proceeds of Crime and Anti-Money Laundering Amendment Bill, National Assembly Bill number 39 of 2021, be now read a second time. Will as many as of that opinion say aye? Aye. Many as of a contrary opinion say nay? Nay. The ayes have it.
A bill for an act of parliament to amend the Proceeds of Crime and Anti-Money Laundering Act. Order number 10, the Huduma Bill, National Assembly Bill number 57 of 2021, first reading. A bill for an act of parliament to provide a primary law on civil registration and legal identification management, establish the National Integrated Identity Management System NIMS, provide for enrollment into the NIMS, assigning of the Huduma number and issuance of legal identity documents, facilitate the registration of births and deaths, promote efficient delivery of public services, and for connected purposes. Order number 11, motion, consideration of the Senate amendments to the National Hospital Insurance Fund Amendment Bill, National Assembly Bill number 21 of 2021.
Yes, Leader Majority Party.
Thank you, Honorable Speaker. Honorable Speaker, I beg to move that the Senate amendments to the National Hospital Insurance Fund Amendment Bill, National Assembly Bill number 21 of 2021, be now considered. Honorable Speaker, members will recall that this House did unanimously pass the National Hospital Insurance Fund Amendment Bill, and driven by the need to give Kenyans universal health coverage. And because this bill involved some devolved functions, health being devolved, it was necessary that this bill be referred to the Senate for their consideration as well. And the necessary communication was made to the Senate, and they did consider the bill, and in their deliberations have also enriched this bill by making a number of amendments. And these amendments are contained within our within our order paper from page 1603 all the way to page 1609, both pages inclusive. And the import of most of these amendments is basically, like I'm saying, is enriching the debate on the National Health Insurance Fund to make it more user-friendly, to ensure that whatever we probably missed out has also been taken care of. They've come up with more definitions of, a clearer definition of an employer. They've worked out, who does the accreditation. They've worked out, expanded the definition of healthcare provider to include promotive care. The Senate has also made some distinction between funds paid into the fund and the contributions by employers. And further, Honorable Speaker, they have also looked at the representation within the board and substituted what we had provided for, being the Medical Professions Oversight Board, to a nominee of the Kenya Medical Association, again to ensure that the medical profession is better represented. They've also gone ahead and, recognizing that health is devolved, expanded the number of people appointed by the Council of Governors from 1 to 2. And basically, as you go through it, you will realize that basically all the amendments that the Senate has proposed into this bill are actually geared towards strengthening. Honorable Speaker, one of the things I just want to highlight is in clause 19, we had provided unemployed persons as one of the categories for which the board was to determine a contribution rate. Noting that, this fund is compulsory, it's mandatory for everyone, and that mandatory clause nobody has touched. So it's mandatory for everyone, and we had provided for, within clause 19, for how, for the board to provide for a special contribution by the unemployed. What Senate did is they have actually shifted that from clause 19 and taken it to clause 23, where we had provided for contribution by the youth to now be contributions by all unemployed persons, age not being a factor, whether you're youth or old, so long as you're unemployed. So we not lost anything. We not lost on the mandatory contribution aspect. Everything is still mandatory, and it's up to the board to then look at the different categories and how they contribute to the fund. Noting that also that we still have the proviso that the state will provide for all the indigents and all the people who cannot provide for themselves. So we have not lost anything from that rearrangement, and because that was probably the only concern. The other fundamental issue that they have changed is obviously we had provided for private employers to only top up the amount of contribution so that it's at par with what the unemployed, what the self-employed contributors do. But what the Senate did look at, and rightfully so, is that we probably will, the amount that will be earned from that top up from say 300 to 500, that 100 shillings may not be enough for the kind of money we need. And if the employees of the public, or the employer being the public, the county governments and the national governments, if they are mandated by law to match the contribution, it will be discriminatory on the public sector to match contributions while the private sector does not do the same, yet both are employers. So for equity purposes, let every employer contribute, with a proviso that where an employer already has a medical insurance that is at par or better than NHIF, then they will be exempted from the double contribution. And I think that's a fair argument, which the committee has also agreed with. Honorable Speaker, I believe the rest of the amendments, members, again, in terms of the fines, just rationalizing in clause 20, the fine from 1 million to 500,000, and also looking at who bears the burden in clause 21. Like I said, in clause 23, removing the youth and covering the broader picture of everyone who is unemployed. And the one new innovation that has come in is that within clause 26, the Senate has added the range of benefits or emergency treatment to cover some of these rare conditions like primary angioplasty, thrombosis, thrombolysis and rescue angioplasty, and such other treatment as a board may determine. And I believe this is basically broadening the scope of the coverage for the Kenyan people. I think the only other bit that one would want to highlight is, again, the issue of the board will not just revoke, a body that has been empaneled without notifying them of that intended revocation, which again is in line with our constitution in terms of fair treatment, fair administrative justice, which we had not provided for, and creates a situation of how that revocation will be processed to its final conclusion. The Honorable Speaker, I believe, again, most of these other amendments are basically minor tidying up, and it's also a fundamental new clause in 26 by the Senate is that provision that the board shall not withdraw the benefits of a person who is undergoing treatment for a chronic illness, because that would be so unfortunate. One is already chronic, and immediately that chronic sickness sets in. If the board was to withdraw the benefits, it would actually be a death sentence on the person. So, Honorable Speaker, I believe that as a mover of the bill, I've looked through these amendments. I've had consultations with all the various stakeholders. Various stakeholders also did appear with the Health Committee, and the Health Committee will also be giving us our views. But I have no reservations in terms of what the committee has done, what the Senate has done, and I would recommend to this House that we do agree with the amendments by the Senate so that we can take this bill to the next level to assent, and hopefully, beginning of the year, we can start getting the benefits of universal health coverage to our people who now have to sell their land, who have to auction their property to pay simple medical bills, whereas we have the means to actually provide that cover for them. We have the means to insulate them from poverty and from the indignity of having to suffer from sickness and being impoverished forever because a family member has become sick. So, Honorable Speaker, I want to plead with the House that we take this bill to the next level, agree with the Senate, and then we can at least go to the Committee of the whole House in the next order so that we can then process each of those amendments. And by the end of this session, we will have given Kenyans the Christmas they so much deserve. With those words, I beg to move and ask the Honorable Chair for Health, the Honorable Sabina Chege, to second.
Thank you, Honorable Speaker. I second.
All right. I propose a question, which is that the Senate amendments to the National Hospital Insurance Fund Amendment Bill, National Assembly Bill number 21 of 2021, be now considered. Seeing no interest, I put the question, which is that the Senate amendment to the National Hospital Insurance Fund Amendment Bill, National Assembly Bill number 21 of 2021, be now considered. Will as many as of that opinion say aye? Aye. Many as of our contrary opinion say nay? The ayes have it.
Order number 12, Committee of the Whole House.
Order members. Order members, we are now in the Committee of the Whole considering the National Health Insurance Fund Amendment Bill, National Assembly Bill number 21 of 2021.
Senate amendment to clause 7.
Honorable members, I propose a question that the Senate amendments to clause 7 be now approved. We have no amendment to it. I therefore put the question that the Senate amendments to clause 7 be now approved. Will as many as are of that opinion say aye? Aye. Will as many as are of the contrary opinion say nay? The ayes have it.
Senate amendment to clause 8.
Honorable members, I propose a question that the Senate amendments to clause 8 be now approved. We have no amendment to it. I therefore put the question that Senate amendments clause 8 be now approved. Will as many as are of that opinion say aye? Aye. Will as many as are of the contrary opinion say nay? The ayes have it.
Senate amendment to clause 9.
Honorable members, I propose a question that the Senate amendments clause 9 be now approved. I now put a question that Senate amendments to clause 9 be now approved. Will as many as are of that opinion say aye? Aye. Will as many as are of the contrary opinion say nay? The ayes have it.
Senate amendment to clause 10.
Honorable members, I propose a question that the Senate amendments to clause 10 be now approved. I now put the question that the Senate amendments to clause 10 be now approved. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Senate amendment to clause 14.
I propose the question that the Senate amendments to clause 14 be now approved. I now put the question that the Senate amendments to clause 14 be now approved. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Senate amendment to clause 15.
I propose the question that the Senate amendments to clause 15 be now approved. I now put the question that the Senate amendments to clause 15 be now approved. With as many as are of that opinion say aye. With as many as are of the contrary opinion say nay. The ayes have it. Honorable members, it's good to note that we have some words inadvertently omitted from that clause. The words "if the person" should be included after the words subsection 1 for proper grammatical flow. It's just a grammatical issue, and the clerk will take note of that. Just a clean up.
Senate amendment to clause 19.
Honorable members, I propose a question that the Senate amendments to clause 19 be now approved. I now put the question that the Senate amendments to clause 19 be now approved. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it. Still on that, I think there is a bit of cleanup on this bill, really. There is a cross-referencing error. The correct reference should be subsection 2A and not section 6C, as indicated in the amendment. That the clerk will correct. It's just a grammatical issue.
Senate amendment to clause 20.
I propose a question that the Senate amendments to clause 20 be now approved. I now put the question that the Senate amendments to clause 20 be now approved. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Senate amendment to clause 21.
I propose a question that the Senate amendments to clause 21 be now approved. I now put the question that the Senate amendments to clause 21 be now approved. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Senate amendment to clause 23.
Sorry, honorable members, just allow me to go back on clause 21. There is also a grammar issue. In the proposed amendment in paragraph B, we note that the words should be inserted immediately after the words incurred by the employee for proper grammatical flow. Clerk is advised to pick on that.
Senate amendment to clause 23.
Honorable members, I propose a question that the Senate amendments to clause 23 be now approved. I now put the question that the Senate amendments to clause 23 be now approved. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it.
Senate amendment to clause 26.
I propose a question that the Senate amendments to clause 26 be now approved. I now put the question that the Senate amendments to clause 26 be now approved. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it. Honorable members, still on that clause 26, yet another grammatical issue. We note that there is a cross-referencing error in the proposed new subsection 3C. The correct reference should be, therefore, be sections 3, subsection 2A, 4, and 5, 15, 22, and 43. That's just a cleanup issue, honorable members.
Senate amendment to clause 27.
Honorable members, I propose the question that the Senate amendments to clause 27 be now approved. I now put the question that the Senate amendments to clause 27 be now approved. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Senate amendment to clause 33.
I propose a question that the Senate amendments to clause 33 be now approved. I now put the question that the Senate amendments to clause 33 be now approved. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Senate amendment to clause 35.
Honorable members, I propose a question that the Senate amendments to clause 35 be now approved. I now put the question that the Senate amendments to clause 35 be now approved. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Senate amendment to clause 36.
Honorable members, I propose a question that the Senate amendments to clause 36 be now approved. I now put the question that the Senate amendments to clause 36 be now approved. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Senate amendment to clause 39.
Honorable members, I propose a question that the Senate amendments to clause 39 be now approved. I now put the question that the Senate amendments to clause 39 be now approved. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Senate amendment to clause 44.
Honorable members, I propose a question that the Senate amendments to clause 44 be now approved. I now put the question that the Senate amendments to clause 44 be now approved. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it. Honorable members, still on that clause 44, we know that in the proposed new section 45B, there is need to include the words 32A5 at the end of the sentence for purposes of coherent flow in that particular clause.
New clause 26A proposed by Senate.
I propose the question that the Senate amendments relating to new clause 26A be now approved. I now put the question that the Senate amendments relating to clause 26A be now approved. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it. Honorable members, we are done with that particular bill. Mover.
Honorable Chairperson, I beg to move that the committee do report to the House its consideration of the Senate amendments to the National Health Insurance Fund Amendment Bill, being National Assembly Bill number 21 of 2021, and its approval thereof without amendments.
Honorable members, I put the question that the committee do report to the House its consideration of the Senate amendments to the National Health Insurance Fund Amendment Bill, National Assembly Bill number 21 of 2021, and its approval thereof without amendments. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Honorable members, Mr. Speaker.
Chairperson. Honorable Sabina.
She's the chair of the committee. Committee of the whole House. Okay.
Honorable Speaker, I beg to report that the Committee of the whole House has considered the Senate amendments to the National Health Insurance Fund Amendment Bill, National Assembly Bill number 21 of 2021, and approved the same without amendments.
Mover of the bill.
Honorable Speaker, I beg to move that the House do agree with the committee in the said report. Honorable Speaker, I also want to thank the members for having agreed to the committee, to the Senate amendments, and having participated in the processing of this, and that for one, they'll be now on the right side of history as we give Kenyans this universal health coverage. I request the Honorable Kutuni to second the motion for agreement with the report of the Committee of the whole House.
Yes, Honorable Kutuni.
I second.
Order member, Honorable Whip. Honorable members, I propose a question which is that the House do agree with the committee in the said report. Honorable members, I put a question which is that the House do agree with the committee in the said report. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it. Honorable members, we are done with the morning sitting. Order, members. The time being 11:57 a.m. This House started adjourned until today, Tuesday, 21st December 2021 at 2:30 p.m.